Now let that sink in for a few minutes. The defendant accepts an Alford plea, for example. But he or she does not understand they could get a harsher sentence, or they may even have difficulty in future parole issues. And do jurors really understand beyond a reasonable doubt? Because when they go into deliberation, they go by speculation and their emotions. So I believe as officers of the court, attorneys, judges, prosecutors, defense counsel, we need to do a better job in educating our clients and the jury. But even so, defendant, pro se, have an obligation to be proactive. And here is what I mean. In Gideon versus Wainwright, 372 U.S. 335, it's a 1963 case. Clarence Earl Gideon was charged in Florida State Court with felony breaking and entering. When he appeared in court without a lawyer, Gideon requested that the court appoint one for him. According to Florida state law, however, an attorney may only be appointed to an indigent defendant in capital cases. So the trial court did not appoint an attorney to Gideon. Gideon represented himself in trial. He was found guilty and sentenced to 5 years in prison. Subsequently, Gideon filed a habeas corpus petition in the Florida Supreme Court, arguing that the trial court's decision not to give him counsel violated his constitutional right to be represented by counsel. The Florida Supreme Court denied habeas corpus relief. Gideon filed a petition for writ of certiorari to the United States Supreme Court. The court granted Gideon's petition. The United States Supreme Court reversed and remanded and unanimously opined in part that the Sixth Amendment's guarantee of counsel is a fundamental and essential right made obligatory upon the states by the 14th Amendment. The Sixth Amendment guarantees the accused the right to the assistance of counsel in all criminal prosecutions and requires courts to provide counsel for defendants unable to hire counsel unless the right was competently and intelligently weighed. And reading the case, it's clear that Gideon made the court aware that he did not understand the language, the law, the process. That was why he asked the court to appoint him counsel. Kudos to the United States Supreme Court. So if you don't understand a term, if you don't understand what it means, what it is fully involved, say something. Let your attorney know it. Let the prosecutor know it. Let the judge know it, because it could be literally a matter of life and death. And there's no time to be shy. You gotta be bold. Say something to preserve your right for appeal. What do I always say? Be proactive, be empowered.